Lawsuits can be a landlord's worst nightmare. As property owners, it's crucial to be aware of these pitfalls to protect your investments and maintain good relationships with your tenants. The first thing to look for is improper wording of your advertisements. Misleading or discriminatory ads can lead to lawsuits. For example, stating no children allowed is a discriminatory and violates fair housing laws. Ensure your ads are inclusive and focus on the property's features rather than who you want as a tenant. Second, improper denial of applicants. Rejecting applicants based on race, religion, or other protected classes is illegal. Always have a consistent screening process based on objective criteria like credit score and rental history. It's best practice to have a written criteria. That way, anyone can review what your acceptance and denial threshold is. If you choose to deny someone based on your criteria, document your reasons for denial to show compliance with fair housing laws. Third, improper handling of service or comfort animals. Unlike pets, service animals are not subject to pet policies or fees. For instance, if a tenant with a disability requires a service dog, you must accommodate them. However, you are still allowed to screen the service animal. By doing this, you can assure that the animal hasn't been violent in its past. Familiarize yourself with the ADA and Fair Housing Act to ensure compliance. And fourth, improper handling of mold or habitability issues. Tenants have the right to a safe and habitable living environment. If a tenant reports mold, address it promptly and document your actions. Ignoring such issues can lead to health risks and costly lawsuits. Based on our lease, the tenant has the right to get a mold test. It would be at their cost, and if the mold results came back high, the owner would not only reimburse for the mold test, but would be required to mitigate the mold issue. Fifth, improper service of a rent increase. Many regions have specific requirements for notifying tenants of rent increases, often requiring a written notice within a set time frame. Always check local regulations and follow them meticulously. Our lease dictates a 3% standard rent increase. However, there have been times at lease renewal that the market is dictating a higher increase. As long as you are properly notifying the tenants and getting the increase in writing signed by all parties, you are covered. Sixth, improper entry into the home. This is a big one. Landlords must provide reasonable notice, usually 24 hours before entering a rental property for the inspections or repairs. Entering without notice can be considered trespassing and lead to legal action. We do have a stipulation in our agreement that if they call for an emergency, we have the right to enter whenever, whether they are home or not. Same with service requests. By them submitting a service request, it is giving their approval to allow us in the home. We do try to accommodate their schedule and potential desire to be present, but we respect the tenant's privacy and adhere to the notice requirements that we need in order to maintain the property. Lastly, improper deposit return. Failure to return the deposit within the required time frame or making unjustified deductions can lead to lawsuits. For example, in many states, you must return the deposit within 21 to 45 days after the tenant moves out. A deduction to the deposit can be things for cleaning the property, actual repairs made from tenant damage. You need to show proof of these paid invoices though. This is not the time to get a wish list or wear and tear items paid for by the tenant. Always provide the itemized list of deductions, copies of receipt, and the statement of deposit to ensure compliance with state laws. Being aware of these common pitfalls and taking proactive measures can help you avoid costly lawsuits and maintain positive tenant relationships. Always stay informed about local and federal regulations.